I'm gonna see if, that's good.
Yeah.
I'm gonna see if Marcia can do that.
Good afternoon, Your Honor.
Afternoon, Judge.
Good afternoon.
How are you?
Good.
Your Honor.
Hello. So, and Mr. McGuire, will you be arguing today, or Mr. Sexton?
Actually, I will be doing the argument. Actually, Your Honor, at this time, I have another case in the 49th District Court of, it's in Hidalgo County. And I probably could go with this, if whatever your schedule is like, they could probably put me at the end because that's a relatively new case, but wherever you belong, wherever I belong.
Well, if we get Mr., and we heard from Mr. Donati, I don't see him here yet. Yeah, I'm hoping that your case, Ford Motor Credit and Galasso, will go pretty quickly.
Yes, sir.
If that's the case, we can try to knock it out, but we need Mr. Donati to get here.
Yes, sir.
Good afternoon. There's Mr. Donati.
Good morning, Judge. Or afternoon.
Good afternoon. Is that Mr. Donati?
Yes, sir.
Okay. So now are you going to be here with a video, or you just audio?
Oh, I thought I was video. Sorry.
Yeah, just
Hold on.
now we see something. Good. Okay. Now we can see you. Now we just get you to unmute and.
Okay.
All right. Well, we got a couple family law cases, and then this Ford Motor Credit, which I guess Mr. McGuire, how long do you anticipate needing for argument on that, on Ford Motor Credit?
Well, Your Honor, I think I'll be very brief. I know Mr. Donati has issues. It probably depends on what he raises and what we talk about in that respect. For me, I think say 5 minutes.
Okay. And Mr. Donati, about how long do you think you need?
No more than that, Your Honor. I really don't have a defense. My client owes the money.
Okay.
I mean, there's no. I'm not going to waste court's time with some argument that's esoterical. They owe the money. They couldn't pay for the equipment. The equipment's been returned, and all I'm worried about is making sure there's not a deficiency on it. But other than that, I mean, we don't have a defense. We owe the money.
Okay. Well, why don't we just go? Let's just go ahead and do this one so we can knock it out. So this is cause number 19 CV 6028, Ford Motor Credit versus Lori Galasso and Thomas Galasso. And Mr. McGuire, you're the movement. You want to proceed?
Thank you, sir. The defendants purchased a 2017 Ford Super Duty F550 DRW on March 17, 2017 by written agreement through Appel Ford Mercury Incorporated. The arrangement was for 72 monthly payments at $1,600 per month starting May the 1st, 2017. The last payment received by the plaintiff was on December 18, 2018. This was the event of default. The vehicle was then repossessed on March 4th, 2019. The vehicle was then sold at auction on April 18, 2019 for $36,300. Pursuant to the Texas Business and Commerce Code, the defendant was sent the notice of sale of the vehicle by regular first-class mail, postage prepaid. This is shown on the next to last page of the business record affidavit attached to this motion, where it states charge off. After all lawful credits and deductions, a deficiency amount remains due and owing in the amount of $36,118.59, for which plaintiff seeks judgment, plus court costs and attorney's fees of $175 per hour for 6 hours of legal work that was necessary, reasonable, and customary, totaling $1,050. Plaintiff respectfully seeks judgment in these amounts. Nothing further, Your Honor.
Okay, Mr. Donati.
Your Honor, we don't contest that the vehicle was repoed. We don't contest the attorney's fees. His hourly rate is more than reasonable. In fact, it seems low to me for Houston metropolitan area, so I won't complain about that. The only issue that we raised in our response that was on file was whether or not they had met their burden to establish that the sale was a commercially reasonable sale and that they had made all efforts to gain as much or to obtain as much for the vehicle as possible. And so that's the only defense that we have to the proceedings so far, is that we don't believe they've met that burden. And I believe Mr. McGuire probably has responded to that, claiming that he didn't have to. I'll let him argue about that. But our position, Judge, is that they're missing evidence and as a matter of law to establish that they had a commercially reasonable sale.
Okay.
Your Honor, if I may respond.
You may.
Mr. Donati is correct. In my motion, paragraph 4.1 recites the 6 prove-ups for the elements for this kind of claim. And it's number 5, disposition of the collateral in a commercially reasonable manner. I recite also in paragraph 4.2, the following paragraph, that there is a case on file, Great House. It's called Great House versus Charter National Bank. And if the court can look at the head note 1, that states the burdens of either the creditor and the defendant when it comes to creditor, plaintiff, and the defendant for a debt. Really, we've met our burden because we pleaded generally to this claim. And based on what the answer was on file, no more than 7 days before the date of this hearing, there was just a general denial on file. And we're stating in our motion that based on the Great House case, the purpose of allocating the proving of evidence on commercial reasonable sale does not apply here. And that's why we're arguing that the Great House case should allow us to do our motion for summary judgment, because there have not been sufficient pleadings on file which challenge the issue of whether or not there was a commercially reasonable sale. There wasn't any special pleadings by the defendant. So that's our argument essentially. Nothing
Mr.
further.
Donati?
Your Honor, I looked at the rules of procedure and I did not or could not determine that that was a required verified or affirmative defense. I believe the burden of proof is on the entity that sells the collateral to prove that they had a commercially reasonable sale at arm's length and did not, sell it to a brother-in-law or an employee or some other manner in which they didn't derive the appropriate amount. So it was our position that they didn't bring forth evidence to establish that, and therefore they were entitled to summary judgment. That's all I have.
Okay. All right. Well, and based on the pleadings and the argument, the motion for summary judgment will be granted.
Very well. Thank you.
All right.
May I be excused, Judge?
You may. Thank you.
Thank you, sir.
All right. Now I need to find my document. Wait a minute, Judge. Yep. Looking for my docket here. So hold on. All right, so we got 2 cases left that both sides of the sale take a little bit longer, Zascoda and Johnson. So unless, I think somebody was waving at me earlier, but.
That was me.
Okay.
I was waving at John, actually.
Oh, okay. All right, so is everybody ready here on Zascoda? We've got Mr. Panzica and Ms. Vela.
Yes, we're present and ready, Judge.
Okay, and about how much time do you anticipate you'll need?
Well, it depends on whether or not the court disposes of our motion as we presented it, but I believe Ms. Vela has the burden of proof on this request for 2 specific injunctive relief. So I'm not sure exactly her time frame. I'll be relatively short. All I have is a motion to exclude all of her evidence and also a motion to extend the protective order that was previously entered, and that will require an evidence hearing.
Okay, and I could tell both parties in this case, before I get to Ms. Vela, there were a whole lot of papers that were filed Friday and this morning. I think we got about 100 pages worth of stuff. So I haven't had a chance to look through all of that yet, but Ms. Vela, about how much time do you think you would need?
Good afternoon, Your Honor. I anticipate an hour if the court allows me to present evidence on the request for the 2 injunctions.
All right. And then go down to Johnson.
Here, Judge.
Good afternoon, Your Honor.
Okay, so I think it's a motion to clarify, and I guess Mr. Adams, about how much time do you think you would need?
Your Honor, I would think no more than 30 minutes.
And Mr. Anderson?
Well, I don't think it'll even take 30 minutes, Judge, but.
Okay. I tell you, well, let's try to do the Johnson case first. So. Okay. Okay, so I think the only people I have that should be able to hear, Mr. Anderson and Mr. Adams. Okay. All right, so then it's clause number 2019 L7348, the interest of Drake Daniel Johnson. We have a motion to clarify. I believe, Mr. Adams, that's your motion.
Yes, Your Honor.
And then Mr. Anderson, you're a new attorney on this case, correct?
Yes, Judge, I am.
All right. So, Mr. Adams, you may proceed.
Your Honor, just for a little background, especially since Mr. Anderson just got on the case, we had an original petition for divorce that was filed in April of 2019. In September of 2019, there was an agreed decree of divorce that was entered in this case. That decree, a couple of things that are relevant today. It gave mom a primary custody of the child. It gave dad virtually a standard possession order, made the rights and the duties in that case independently exercised. It set the geographic restriction of the parties and the child's residence to the state of Texas. It established exchange locations for that child that were to be mutually agreed upon. And it also allowed mom to continue homeschooling the child. Now, subsequent to that divorce, dad filed a motion to clarify with this court back in June of 2020. There was a hearing held on June 29th, 2020 on dad's motion to clarify. At that hearing, this court recognized dad as the primary custodian and clarified that mom would now have access to the child according to a standard possession order. July 10th, 2020, a contested entry hearing was held, and this court entered an order establishing a standard possession order, and dad is the primary custodian. On August 4th of 2020, mom filed a motion for modification. She claimed that primary custody needed to be flipped on an emergency basis. Later, she would admit to the court that her complaints had occurred before the last order in the case. And this court ended up dismissing that motion and assessing attorney's fees of $750 against mom. November 25th of 2020, dad filed a proper notice with this court that he was changing the child's residence according to the geographic restrictions stated in the final order. And within a few days of filing that notice, we received communication from mom, myself, and dad that she would not be following that order and that she would no longer be picking up the child from dad's residence. We tried to work out a deal with mom. We were unable to do that. So on December 23rd, 2020, we filed another motion to clarify final judgment. Specifically, Your Honor, what I'd like to do is direct the court's attention to the motion that we filed on the 23rd. At the bottom of the first page of that motion, Your Honor, and the top of the second page of that motion, it outlines the exact language in the order that's in controversy. Specifically, it's the pickup and return exchange language related to the child. If you look at those general terms and conditions in that order, there's a contradiction between section 2 and section 3 in those general terms and conditions, right? Paragraph 2 says that mom should return the child to dad's residence, and then paragraph 3 said that dad should pick up the child from mom's residence, obviously in contradiction. So, Your Honor, we filed a proposed order last Friday. What we're asking this court to do is we're asking this court to clarify the language that's in that final order, right? And by clarify, we mean we want the language changed so that it will track exactly what's in the family code, the general terms and conditions section. Now, we filed 2 exhibits. Our first exhibit, which is M1, is just section 153.316 of the Texas Family Code, which is the section related to general terms and conditions for a standard possession order. And the court can see exactly the language that the family code says is supposed to be included in a standard possession order regarding pickups and returns of a child. Now, Your Honor, our exhibit M2 is the specific language that we have changed from the last order. So the highlighted section on M2 is the section from the last order that we are proposing to change so that it now reads exactly like the family code section regarding pickups and exchanges for a standard possession order. Your Honor, I would just conclude by saying that this court ordered, when we had our clarification hearing, that mom was to have a standard possession order. What we're asking this court to do now is to enter language into that order that would make the pickups and the return language match exactly what's in the family code. That's all I have.
All right, Mr. Anderson.
Judge, our argument to that is, in fact, it says in section 2 on page 14, surrender of the child by Ms. Johnson shall be at the residence of Teresa Johnson, which if you go to 153 of the family code, when it talks about general terms and conditions, the managing conservator shall surrender the child to the possessory conservator at the beginning of each period of possession at the residence of the managing conservator. If the possessory conservator shall be ordered to do one of the following: they can surrender the child to the managing conservator at the end of each period of possession at the residence of the possessory conservator, which is what's outlined in number 2 in this order on motion to clarify. And that's what we're asking the court to do. Mr. Johnson chose to drive to go and move up to the Dallas area. And now he expects Miss Johnson to go up there and come back, and at no expense to himself. Just, he wants her to do all the hard work. That's what this has always been about. He doesn't care about anything but himself and making her do everything. And it's outlined in the order that she should pick up from him, which she's been doing, and that he should pick up from her. That's fair to both parties. That's what the code says. This whole deal of the code says he's supposed to drop him off to her at his residence and she's supposed to drop him back off at his residence is egregious. That's crazy talk. And the fact that Mr. Adams thinks that should take place when he drafted the order and he put it in there that she should pick up from the dad and that the dad should pick up from her. And we think that's what the court should do to make it fair on both parties and to not have it cost one party way more than the other. And it also tracks the family code when he picks up or she picks up from him and he picks up from her.
Okay. And well, I tell you what, and going back to Mr. Adams, you said there's a conflict between paragraph 2 and 3.
Yes, Your Honor. If you look at the motion, because I quoted the language in the motion. So if you look at the bottom of page 1 of my motion and the top of page 2, Mr. Anderson is talking about paragraph number 2. That's the language that he wants. And I'm saying that paragraph number 3, right, is in contradiction with paragraph number 2. That's what we need the court to clarify. We need the court to clarify which language is supposed to be used, because as Mr. Anderson correctly pointed out, I drafted this order and this order was drafted incorrectly, and that it has language that says both. It has language that says mom is supposed to pick up the kid from dad, and then it has language that says that mom is supposed to return the kid to dad. That was signed by the court. Now, the family code makes it clear, right? The family code says this court, any court, can order either one. It can either order mom to pick up from dad, or it can order for those exchanges to be the other way, right? Our argument is contradictory to what Mr. Anderson said, right? Mr. Johnson has moved in this case pursuant to the terms of the order. The geographic restriction in the order was the state of Texas. Mr. Johnson properly exercised his right to live inside that geographic restriction and properly notice the opposing party and the court of that change. Now, if the court would like to hear testimony from Mr. Johnson about why he did that and why the harassment from Mrs. Johnson was part of that and how justified it is, or if we'd like to talk about attorney's fees that Miss Johnson owes Mr. Johnson about what's right and fair, we can do that.
Judge, that's not in this order to be clarified. If he wants to bring a separate motion, that's fine, but
Mr. Anderson brought up what's right and fair, Your Honor.
All right. Well, if there needs to be a clarification between these two paragraphs, the clarification will be that, again, mom picks up at the beginning of her period of possession at dad's house, then dad will pick up at the beginning of his period of possession at mom's house. Okay.
Thank you, Judge.
So,
are we done?
Wait a second. Go back to Mr. Adams.
Well, I assume that's Mr. Anderson's language that we're embracing. So who do we want to enter the new clarified order that's going to have the correct language?
And I'm looking at the language here, which is the paragraph now that is going to be incorrect.
On the thing that I was looking at, the proposed order on motion to clarify that was sent to my client. It was page 14. And so section 3, return of child by Teresa Lynn Johnson should be taken out.
Okay, if I'm looking at the proposed, let's see if we can just do this with the proposed order that's filed. So looking at the proposed order, see, now we're going to be with parents who are more than 100 miles apart.
Your Honor, just for clarification, though, the pickups and the return language is the same regardless of whether they're under or over 100.
What, in the order, what page is that on?
On mine, it's 14, Judge.
Your Honor, we're not going to be able to use this order.
Okay, well, did, say, Mr. Anderson, did you get this in a Word document that you can?
No, Judge, I believe they sent it to, they just e-filed it and e-served me. They didn't send it to me in any kind of Word format.
And I realize sometimes it's preferable to have a nice clean order that has everything from A to Z, so there's no question that what we're going on.
Judge, if I may, the proposed order that they e-filed on Friday, if they could just change the term to, instead of it being where my client drops off at the residence of their client, and just changes it to my client drops off at her own residence, I think that clears it up, and they can send it to me. I can verify it and get it to the court.
I'm willing to send Mr. Anderson the Word document. He can make the changes that he wants to, but I'm pretty uncomfortable making changes to a final order for his client.
Okay, if you want to send him a Word document, but to clarify that at the, mom will, I guess, surrender at the beginning of, dad's period of possession at mom's house, and dad surrenders at the beginning of mom's period of possession at dad's house. So we're clear on that?
Yes.
Okay. All right. So then, Mr. Adams, you could just send Mr. Anderson that order in a Word document, and he can modify that. And then I guess Mr. Anderson, if you send that back to Mr. Adams so he could see that, how much time will we need to get that back to me? Yes. First of all, Mr. Adams, how quickly you think you can get it to Mr. Anderson?
Today.
All right. And then Mr. Anderson, how quickly you think you can get it back?
I will try to get it back, depending on what time I get it today, back to him this afternoon. It shouldn't be too complicated of a task. So okay. I think by end of the week, we could have it to the court.
Okay. So why don't we just have an entry on Friday the 5th? All right. Anything else on this one?
No, Your Honor.
All right. Thank you. I'll be excused.
Good.
Okay, now we'll see if we can get everybody back on Zascota. Okay, so I see Mr. Panzica and Miss Vela and Miss Zascota. I guess Mr. Zascota is behind Miss Vela.
Yes, Your Honor, he's here.
All right, is there anybody else?
think that Mr. Zescoda is in Penzika's office, then another one, and that's too close to school.
Okay. So I guess, Mr. Penzika, if I get you to unmute,
You hear me now? I'm sorry.
I can hear you. And the only question is going to be whether or not there's going to be feedback with your client.
She's not in our office, Judge.
Okay.
Excuse me.
All right. So I guess the first thing let's talk about, and I'll tell you what, this is clause number 2020L7590 in the matter of the marriage of Courtney Zascoda and Donald Zascoda. So I guess Mr. Penzika, if you'd announce.
Yes, sir. May it please the court. I represent Courtney Zascoda. She's the petitioner in this petition for.
And Ms. Vela.
Yes, Your Honor, I represent Donald Ray Zascoda Jr. He's the respondent counter petitioner on this matter.
All right, so why don't we hear first, I guess, from Ms. Vela about if I can consider the things that were just recently filed.
Yes, Your Honor. So this case was mediated back in November of 2020. Their issues were mainly carved out subject to two injunctions, requests for injunction that they be mutual to both parties for no drinking when the child's in either parent's possession, and a request for a morality clause. This case, Judge, I came into it back in December after other attorneys had served for both petitioner and respondent. It was a quite voluminous file, and I do apologize to the court for sending so many documents this morning, Judge, but I thought it was important for Your Honor to be aware that discovery had been turned over to Mr. Penzika, detailing the request for the injunction, specifically the alcohol provision. Mr. Zascoda, in his original filing, his original answer and counter petition, did request from the court temporary orders and temporary injunctions, including on number 14, letter LL and MM, which are specific: consuming alcohol within 12 hours before or during the period of possession of the child, and the morality permitting an unrelated adult with whom the counter-respondent has had an intimate relationship between the hours of 8 and 8. The reason why I point this out to the court, Judge, is because this is not something that Mr. Zascoda recently thought to add in or at the last minute request from the court. The parties were married for approximately 7 to 8 years, and their son is 6 years old. There's been testimony to the court that the child needs some therapy, and we believe that there are ongoing issues with alcohol. So we would respectfully request that the court allow us to provide some brief testimony and evidence to the court for the court's consideration. All of this was pleaded by Mr. Zascoda and then subsequently repled in his respondent's motion to modify temporary orders that was filed back in September of 2020. I would ask the court to take judicial acknowledgement and notice of the pleadings in the court's file detailing Mr. Zascoda's request for this specific relief. And we would ask that the court entertain evidence today, because we believe that it is in the best interest of the child that these two important injunctions be mutually granted against both parties.
All right, so Mr. Penzika, what's your argument against considering these things?
Yes, sir. By way of background, Judge, if the court will take judicial notice of the court's file relative to a certificate of delivery of discovery that was propounded, I think on June 19th of last year, 2020. If the court will recall, at the original filing of this divorce action, Mr. John Anderson was my client's attorney at the time, and Mr. Anderson propounded written discovery to then counsel Josh Clover in the form of written interrogatories, request for production, and a request for disclosure. Likewise, Mr. Clover propounded discovery to my client as well. And that was last June or July. And so we had this competing discovery that was propounded that never got answered by anyone. And part of the reason is, before I became counsel, is because Mr. and Mrs. Saskota were going to make an effort to try to reconcile their marriage. And as a result of that, neither of the attorneys or the parties answered the discovery in the case. There was no Rule 11 agreement to abate the discovery, which would have been a proper mechanism, in my humble opinion, to abate the discovery until notice was given one way or the other. That was never done. None of the lawyers filed the discovery responses. When I got involved in the case, and I took over the case, and I want to say it was in early August of last year, I noticed the discovery was conspicuously absent, both parties. I sent a email.
And I tell you what, we're getting some feedback from Mr. Panzica.
Okay. Maybe my volume's too high, Judge. Any better now?
We'll give it a try.
Okay. And when I took over the case, I sent an email to Mr. Clover, and I said, basically, Josh, no discovery has been done by either party. Would you like to do a Rule 11 to define a date and time certain for us to exchange the discovery in the case? I did not hear back from Mr. Clover originally, but he did set a hearing, I want to say, on additional temporary orders or something to that effect, because the original agreed temporary orders that was entered back in April.
Can you hear okay? And I just, is there, Mr. Panzica, is there another laptop maybe that's on Zoom in your office?
No, Deborah's here, but she's not on.
I got off, yeah.
Okay.
Is it still feeding back?
Yes.
Okay, Deborah, you know how to fix it.
No.
I don't know how to fix it. Let's see.
Hi, Judge. Hi, everybody. I don't know. I mean, we don't have a, let's look. Let's just speakers.
Speaker, headphone, audio settings. I don't.
No, whoop. Did I lose them?
I can still hear you.
Okay, good. Okay. I don't know. I have my iPad, but I logged out of the Zoom meeting. I could take the iPad out of here, see if that.
Put it in the other room.
Okay.
Well, let's see if that helps.
Let's just
But I
see.
don't have it on, so I don't know.
It's not on. So. Anyway, is it any better now?
Yeah. Now I'm not hearing it when you just spoke, so maybe that.
Okay. Well, let's try to move forward then.
Okay.
In any event, the parties had entered into an agreed temporary order at the original setting in April of last year, but it never got entered. Just like the discovery never got done, the temporary order never got entered. And when I got involved in the case, I looked at the temporary order. I got a copy of the transcript that the court had entered, and we drafted a temporary order, and ultimately it was set for sometimes in, I think, September, as I recall. At that period of time, Josh had never answered the discovery. He never did a Rule 11. He never suggested we have a mutual date to exchange discovery. But in anticipation of that hearing, what I did receive from Mr. Clover was I received, and I put it in my motion to exclude, Judge, which I also asked you to take judicial notice of.
Now take judicial.
Thank you, Judge. I specifically pointed out in there that the interrogatories were never answered, ever, even to this day as we sit here, by Mr. Zascoda. The request for production, the request for disclosure, designating witnesses was never answered even to this day. And the request for production was not answered at all until, as indicated on page 2 of my motion, on September the 22nd, where Josh Clover, in anticipation of this upcoming hearing, bait stamped certain documents, certain photographs predominantly. And I think in part, that's what counsel and Mr. Zascoda is now relying upon as a formal response to the request for production. I don't need to tell the court what the rules require in responding to requests for production. He did send some photographs. It was not in the form recognized under the Texas Rules of Civil Procedure. It was not interlineated underneath question and attached as the production pursuant to 196.2, although they were bait stamped. And that's what he produced on that date. And a few weeks later, he produced some more photographs, none of which were earmarked to the questions that were propounded or referenced to the questions that were propounded. And none of which was obviously not timely produced because it was more than 30 days from the time they were originally issued. Now, and I put that in my motion as a form of disclosure to the court that in fact some effort was made by Mr. Clover to produce, but it was not in compliance with the rules. We chose not to file a motion to compel, which we could have obviously filed in a request for attorney's fees. Instead, what happened is that 30 days before trial, the original trial setting, Judge, not today's trial setting, I want to say that I didn't write down the original trial date. I thought I did. Yeah, I want to say it was sometimes in December, if I recall. And so out of an abundance of caution, since we didn't have a Rule 11 agreeing to exchange discovery, I supplemented unilaterally my client's discovery 30 days before trial. I want to say that was sometimes on, I wrote it down, I can't even, whenever it was 30 days, excuse me, I think it's November the 10th. We supplemented with a trial date, I want to say roughly, and you can take the judicial notice, I want to say on December the 10th. So we supplemented. They never did supplement, ever. Now, I appreciate Ms. Vella's position about taking over this case. If you look at the file itself, Judge, she filed a motion for substitution of counsel on December the 3rd. After we had a mediated settlement agreement where Mr. Clover was the attorney of record, a mediated settlement agreement that resolved all issues in this case, except for the 2 injunctions which were raised at the last minute during the mediation process. Counsel's motion for substitution was on December the 3rd. That's been 60 days today, if my math is correct, how long she and Mr. Zascoda have been partners in this particular case. We know under the rules, you have 30 days before trial to supplement. So Ms. Vella and Mr. Zascoda had from December the 3rd to January 3rd, roughly, to supplement while she was the attorney of record, knowing full well that she had the entire file from Mr. Clover, knowing full well there was discovery that was outstanding. And they failed to produce any documents within 30 days of trial, or 30. Instead, this morning, we get a document dump from Ms. Vela and Mr. Zascoda, primarily, I suspect, in response to our motion to exclude their evidence for violation of the discovery rules, period. So once it came to their attention this morning, excuse me, I filed that, by the way, Judge, 3 days in advance, which is required by the rules, which was last Friday. So over the weekend, I assumed Ms. Vela and Mr. Zascoda needed to file a response, which they did. I got it this morning about 2 hours ago. And I appreciate the response. It's misplaced, but nonetheless, there is a response in the file. And so the end result is this: all of the exhibits and documents they're talking about. And I've gone through the laundry list that's been dumped on us in the last hour and a half. Many of them were never produced originally in September when Mr. Clover made an informal document dump, so to speak, that were bait stamped, but not earmarked to the proper discovery questions or productions that were asked. And so we have a combination of documents that has been dumped this morning. Some have bait stamps back to September, not in compliance. And some I've never seen that are not bait stamped. And the reason they aren't is because they were just engineered this morning or over the weekend, I asked. Okay. So I'm pointing out specifically to the court that discovery is relevant in this case. Discovery was in fact propounded, although both the original attorneys didn't timely produce it. We have produced 30 days before trial, which is the best we could do under the circumstances. Can't put the genie back in the bottle as far as the time is concerned. But they have yet to produce anything to support their position. Now, counsel alluded to a pleading suggesting injunctive relief. Now, that pleading was an original pleading as part of the counter petition for divorce that requested temporary injunctive relief. There was no subsequent pleading, amended pleading, albeit plenty of time to do so, asking for permanent injunctions, ever. Even as we sit here now, no pleadings to support permanent. On November the 20th, when we went to mediation, these 2 injunctive issues suddenly popped up. Strike that. Let me back up. If the court will look at its temporary order, even its temporary order, agreed temporary, did not mention alcohol prohibition or dating someone in a romantic relationship overnight. It didn't contain it. And November 20th, we settled the case except for 2 injunctions. Now, since November the 20th, counsel took over the case December the 3rd. She had plenty of time to amend her pleadings, any time to supplement her discovery. Neither of which have taken place. So what I'm suggesting to the court is that, and by the way, Karina, the trial coordinator, did send out at one time or another an email requesting that we exchange exhibits and witness lists. But it didn't have a date and time certain on it. I assume we should do that by last Friday. That was an assumption on my part since it didn't have a date. And that's when we filed our motion to exclude. their evidence, as well as a motion to extend, I think at one time or another, the duration of the protective order. Now, with that being said, and by the way, we don't have any exhibits. We have no exhibits. We have no witness list because we don't have the burden in this case. And there's no reason for us to produce exhibits that we felt like may or may not be relevant. So the only reason I mention that, Judge, is the document is directly as a result of Ms. Bella and Mr. Zascoda producing belatedly all of these documents. Period. Now, in response to that, that was filed about an hour and a half, 2 hours ago, I did send an e-file of 2 cases to the court that refutes Ms. Bella's position about being able to produce injunctive relief without any pleading, without any discovery being done. I'll be more than happy to address those with the court. So the document dump isn't coming from us because we don't have anything. The only other thing other than those 2 cases is I submitted the request for production that was originally propounded on Mr. Clover by Mr. Anderson back in June. Request for production number 2. That was propounded to Mr. Zascoda, specifically asked for all documents regarding your claims for each of the following. ABC goes all the way down. J, request for injunctive relief. That's what it specifically asked for. It's never been forthcoming. Period. So they're in total non-compliance with the rules. And as far as producing the documents are concerned. Excuse me, I'm sorry, Judge. Now, I need to go on about these 2 cases. I think counsel's response, which I assume the court has looked at or will look at, he seems to be alluding in Kings versus Lyons opinion, which is a 2014 case, that the court can liberally construe pleadings, even when there are no pleadings to support the evidence. Now, I'm not sure if this just is a misstatement on her part, or maybe I need to be corrected, but I'm looking at Roman numeral number 2 in her response and objections to petitioner's motion to exclude. And she recites in there, basically, in matters concerning custody, blah, 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 best interest is always paramount. We've heard this over and over again, and therefore liberal pleadings are in order. However, when you start looking at the cases, you'll see in not only King, but in the interest of AAN, LGN, and NLN, the second, one of the cases we have e-filed, you will see where it says, quote, in part, a permanent injunction cannot stand in the absence of pleadings requesting such relief. The granting of a trial amendment to add a request for permanent injunctions or trial of the issue by consent. We're not agreeing to try this case by consent here, hence my motion that I filed, excluding it. And the end result is if you Google, I'm so sorry. If you in Google permanent injunctions in the Texas Family Code, you will see that there are the word permanent, not injunction. You'll see 94 recitations to permanent in the Texas Family Code. Not one is a reference to an injunction, not one. In fact, if you look at the Family Code, there's not a word about permanent injunctions in the context of the family law case. There's language about temporary injunctions, but not permanent injunctions. So in the absence of that, you have to look to the civil rules or the civil case law on proving injunctive relief if the court was inclined to even entertain it in light of the discovery of CCL. And it clearly places the burden of proof on the party requesting it, albeit not in pleading form. And it requires, according to the AAN, et cetera, case I just mentioned, they must plead and prove, plead and prove, not plead or prove, plead and prove a wrongful act. 1, 2, imminent harm presumptively to the child the subject of the suit. 3, irreparable injury. And 4, an absence of an adequate remedy at law. That is the burden they have if the court was even inclined to entertain it under the circumstances, in the absence of discovery, in the absence of pleading. Now, there is an adequate remedy at law. It's called a modification. It exists. An emergency motion after a decree is entered, supported by affidavit stating an irreparable harm or injury or safety or welfare issue, can be raised. So it's not like Mr. Zascoda does not have some remedy recognized by law. It does not recognize that you can summarily dump hundreds of pages of documents, most of which are not date stamped because they're new to the scenario, without any pleadings, and then expect this young lady to spend her time and her attorney's fees fighting over injunctions that have never been raised properly, and nor or even in the temporary orders of this court, knowing full well the parties had plenty of time to do that if they chose to do it. So I'm asking the court very simply, no judgment can be entered in this case without pleadings to support it. There aren't any. And so I'm asking the court to grant our motion, award us $1,750 in attorney's fees, which I would submit to the court as reasonable and necessary under the circumstances in light of the failure to honor the discovery request and failure to timely plead to raise the permanent injunction. I would say that's reasonable. It's necessary. In fact, the fees could be more than that, but in the interest of resolving it, I think $1,750 would be appropriate, Judge. I'm asking the court to grant it. That's all I have, sir.
All right. So, Ms. Vela, if you want to respond to that, and I can, tell you that I was thinking some of the things that Mr. Panzica commented about the modification, and I have, in quite a few cases previously put the alcohol injunction in place, and depending on different circumstances, the morality clause. So it's certainly something that if it becomes a problem where the best interest of Ryder is at issue because of the morality clause, what we're trying to protect with the morality clause, or from exposure to too much alcohol, that is certainly something I'd consider in a modification. But if you want to respond to the issue of the timeliness of filing the exhibits.
Yes, Your Honor, if I may briefly, as Mr. Panzica told the court, I did come into this case in December, and I learned about the mediated settlement agreement. in the mediated settlement agreement, Your Honor, that's signed by all parties and attorneys, this specific issue is agreed to by everybody. And the issue is the two injunctions, the request for the two injunctions. I don't believe that there's any harm in the court entertaining this request to anybody. I believe that it is sincerely in the best interest of the child that Mr. Zascoda is willing to also mutually be enjoined from these acts. And if the court's inclined to give it a time limit of a year, we're happy for the court to entertain us on that, Judge. But to be basically sanctioned in a death penalty way when I have been communicating with Mr. Panzica's office, and I really thought that these were the only two issues, and I felt blindsided on Friday when he filed this motion, because all along I thought these were the only two things that we were going to be discussing with the court today. The case law is pretty clear, Judge, that these cases, the courts usually do entertain these injunction requests because there's children involved. The case that Mr. Panzica alluded to in his exhibit number 2, this was a party that had been divorced, and this was brought 2 years later. This wasn't even out of a divorce. We believe that Mr. Zascoda did plead in his original motion for actually his original answer and his request for counter petition that these issues were already a problem back in April. The other case that Mr. Panzica notes, the King case, the court goes into an extensive discussion about, as long as the request is supported by a pleading, which we've told the court that there is a pleading on file by Mr. Zascoda, that the court has wide discretion in deciding these things. And if the court would also turn its attention to Peck, that's another case that we submitted to the court where the trial court's given wide latitude in determining the best interests of minor child with regard to visitation. So I do appreciate Mr. Panzica's arguments in the sense that this discovery wasn't properly answered. However, in all of my communications with Mr. Panzica since December, he's never once asked me, are you going to supplement any discovery? And I know that I adopt the case as is, Your Honor, and I don't want to hide behind a veil and say that I should have looked at that more carefully. However, I will tell the court that I was out for most of December with illness, and I did really reasonably believe that our only two issues were these injunctions. So I thought it was important to advise the court of the discovery that had been supplemented to Mr. Panzica in determining these issues. And we would pray to the court to just allow us some testimony by Mr. Zascoda regarding his request for the two injunctions.
Okay. All right. Well, like I said, based on the timeliness of the filing, I'm going to exclude the evidence, but admonish both parties that Ryder's best interest is going to be the thing on the top of the list if I hear anything else about this case. And if alcohol becomes an issue, I won't have any problem putting that type of injunction in place. And if either side have new relationships coming in and out of the house a lot, I wouldn't have a problem, modifying the decree and adding that on there. But as far as today is concerned, I will exclude the evidence. So
that being the case, Judge, we had a motion to extend the protective order, and we're going to pass on that motion in the interest of time, even though I suspect there's some evidentiary factors that the court may want to consider. So we're not going to prosecute that today. I would ask the court if we can use today as a prove-up date, since we have everybody here, to prove up our divorce pleadings, to grant the divorce and pursuant to the MSA, and now the court's ruling denying the injunctive relief. And I'm ready to call Ms. Escoda.
Well, let me get both, I guess, Ms. Zascoda and Mr. Zascoda to raise your right hands. Okay. And is Mr. Zascoda, can you hear me okay? Okay. And you and each of you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Okay. All right. Whoops. Wait a second. Okay. And I tell you what, if we could take about a 5-minute break, and then we'll come back and do that.
All right, Judge. Thank you.
Okay. And so we'll be off the record. I'll tell Miss I lost Miss Vale. I was going to tell her something. I'll do it when we get back. Let me mute myself here.
September 24th? Yes, ma'am.
It's not on.
Is Miss Vela there?
Yes, sir. She's going to get something.
All right. Let's ask her to, there she is.
Yes, sir.
Marty,
Yes, sir.
have you had an opportunity to look at that contempt order we revised and sent over?
I did.
Do you have changes or?
No, just the original ones that I had requested. I think she did all of them. He is paid up in child support and he's already paid the attorney's fees.
Okay.
Yeah, they put it in mail, she said.
Oh, the attorney's fees on the contempt?
Yes, sir.
Oh, well, that's nice. Thank you very much. I thought it was due on like the 8th or something. I don't remember, but
We asked him to get everything paid up so that,
yeah, so he can start it clean. That's a good idea. Perfect. I'm glad to hear that. Thank you very much, Ms. Fellow. Now, so can I tell the judge he can sign the contempt order that's been submitted?
yes,
Okay.
I can agree on the record if you'd like.
I'm sorry?
I can agree to it on the record if you'd like.
That's fine. Whatever you, that's fine. Now, are you over there with, who is it? Paul?
Yes, sir.
How is he doing?
He's doing better. He was a little bit ill last week.
He didn't have the COVID, did he?
No,
Yeah. Well, thank goodness for that.
he's like the Teflon when it comes to COVID. Everybody had it except him in this office.
Really? Wow. Well, my wife Deborah is in quarantine right now because she was exposed. But she's tested negative, and then we're going to go later this afternoon for another test. And hopefully she's negative again. Otherwise, she'll have to be voted off the island here. There's Marty right there.
Hey, Marty, that's really not a bad thing, okay?
Yeah, get voted off the island.
To move away.
Rough. We had it and it was rough. Being mom, you know, the job never stops and you can't.
No.
So
Glad y'all are better.
good luck. I hope everything turns out well.
Thank you.
Now, how long have you been practicing?
I've been a lawyer 12 years now.
Well, did you go to South Texas?
No, I went to Thurgood.
Oh, Thurgood Marshall. Yes, yes, yes. Good.
So I don't owe as much as Paul does.
That's right.
You don't know as much as Paul?
Yes.
I've dealt with Paul. You probably know more.
Oh, I said, oh, student loans.
Huh? What did she say?
Student loans.
I think she said she doesn't owe as much.
Oh, I thought you said you didn't know as much.
She's not that person.
This may not be the best time, but do you think we're totally out of talking on the property?
Yeah, I got your Rule 11, and I'm going to ask Courtney to sign off on it. I think she should. The most recent Rule 11. The only interlineation. You broke down a small tool shed. And then below that, you said tools as if there were more than tools outside the tool shed. So I'm not sure. So I'm going to just interlineate on it, and I'm going to, and I'd like to have it removed in the next 30 days or 20 days or something. All of his, and I realize that he's got vehicles that need to be moved. So that's why we agreed to extend the time period.
Okay. If you want to send it over, I can have him sign it before he leaves, and that way I can get it to you executed on our end.
Okay, then, yeah, I wrote it right there, Deborah.
You want me to scan it and send it to Courtney?
Yeah, why don't you just scan it and send it to Courtney? And can you hear me, Judge? Can you hear, Judge?
Yes, I can.
Good. I was talking to Ms. Vella off the record, and we had filed a proposed contempt order on the back child support and sent a copy to Ms. Vella. And I think, without speaking for her, that we've made all the revisions back and forth, and that what we now filed, we're requesting the court sign. Is that not right, Ms. Vella?
That's correct, Your Honor. We had an opportunity to send our edits and they were adopted. and we're comfortable with it. I would like to tell the court that Mr. Zascoda has paid all of his child support and attorney's fees previously awarded, Judge.
Okay. All right, so then that the order, Mr. Panzeca, that you have, everything's been fulfilled?
On the contempt, well, I haven't seen the money or the child support yet, but I assume it has if that's the representation.
Okay.
But nonetheless, I think we need to sign order.
Okay. All right. Well, then, you ready? All right. So we'll go back on the record, and parties have been sworn. So, Mr. Panzeca, you may proceed.
Okay. I'd like to call Courtney Zascoda. Please state your name.
Courtney Marie Zascoda.
And Ms. Zascoda, are you the petitioner having filed a divorce action against Donald Zascoda Jr.?
Yes.
And prior to filing that divorce petition, were you a resident of Austin County 90 days in the state of Texas 6 months?
Yes, sir.
Is it true that your marriage has become insupportable because of the discord and conflict of personalities between you and Mr. Zascoda?
Yes, sir.
That prevents any reasonable expectation of reconciliation?
Yes.
And simply put, you're asking the court to grant your divorce petition here.
Yes.
Right. And there was one child born of your marriage relationship with Mr. Zascoda, and his name is Ryder, correct?
Correct. Yes, sir.
And what is Ryder's birthday?
8/25 of 14.
Okay. And subsequent to this divorce being filed, did you and Mr. Zascoda attend mediation with Miss Linda McLean, I think back in November 20th of 2020?
Yes, sir.
And did you reach an agreement as it applies to the parent-child relationship issues with Ryder?
Yes.
Basically, you would be named in concert with Mr. Zascoda as the joint managing conservator?
Yes, sir.
And you would have primary care, custody, and control under a joint managing conservatorship arrangement, correct?
Yes.
And additionally, there was a domicile restriction to Austin County and counties contiguous to Austin County, was there not?
That's correct.
Right. And you and Mr. Zascoda in that mediated settlement agreement, which I'd ask the court to take judicial notice of it, having it previously been filed, it addressed child support, access, visitation, health insurance premium, etc.
Yes.
You would not have signed that mediated settlement agreement unless you felt it was in the best interest of Ryder, would you?
Correct.
And do you think it's in his best interest?
Yes, sir.
And you asking the court to approve the mediated settlement agreement as it applies to the parent-child relationship?
Yes, sir.
Additionally, you entered into, as part of that mediated settlement agreement, a partition of both of you and Mr. Zascoda Community and Separate Property Act.
Yes.
And it consists predominantly of a lot of personal property items, as well as, I think, a mobile home that you owned prior to your marriage to Mr. Zascoda.
Yes.
Okay. And that mediated settlement agreement, as it applies to property, addressed all of the personal property as well as the business entity of Mr. Zascoda, as well as the liability associated with his business entities, as well as your mobile home and your financial assets, correct?
Yes, sir.
Simply put, you keep your property, he keeps his property, except those items reflected in the mediated settlement agreement that are effectively still on your property, at least some of them, that Mr. Zascoda has agreed to timely remove, correct?
Yes, sir.
You've authorized me to sign a Rule 11 in concert with you, stating specifically those items that Mr. Zascoda will remove from the premises where you currently reside.
Yes, sir.
You understand he would be required to do that in the next 30 days pursuant to the terms of the mediated settlement agreement.
Yes, sir.
Revised since they were not originally done within 30 days of November 20, right?
Correct.
And do you think the partition or splitting up of the assets and debts between you and Mr. Zascoda is fair and equitable to him as well as to yourself?
Yes, sir.
Are you asking the court to approve that property partition as well as the mediated settlement?
Yes, sir.
One other issue you've asked that your name be changed from Courtney Marie Zascoda to Courtney Marie Rand, R-A-N-D. Is that not correct?
That is correct.
Okay. You're not asking for a name change to avoid any criminal prosecution, are you?
No, sir.
And you're not asking for a name change to avoid any creditor's responses or obligations, correct?
No, no, sir.
I want to point out one item. You agreed to service a debt that I think Mr. Zascoda had incurred relative to some furniture, gallery furniture. Is that not right?
That's correct.
Right. And you are still willing to pay that obligation pursuant to the MSA, right?
Yes, sir.
The problem is you don't have the underlying documents from Mr. Zascoda that will permit you to reach out to a gallery or the collection agency, service that obligation, right?
That's correct.
Are you asking the court to consider, and Ms. Vella and Mr. Zascoda, giving you the underlying documents so you can retire that debt that you agreed to?
Yes, sir.
All right. Pass it.
Ms. Vella?
I don't have any questions of this witness, Your Honor.
All right, Mr. Panzeca, anybody else?
No, sir, that's all. I've drafted a proposed decree. I was waiting until today, so I'll try to clean it up and get it to everybody, and we'll go from here, I assume.
Hey, and Ms. Vella, did you want to call anybody?
I'll call Mr. Zascoda.
You may proceed.
Thank you, Judge. Can you state your full name for the record, please?
Donald Ray Zascoda II.
Mr. Zascoda, you heard the announcement by Mr. Panzeca. Are you in agreement with all of those requests for this divorce?
I guess so, yes.
Okay.
Not really.
And you signed this mediated settlement agreement?
I did.
Okay. And you understand that by signing this mediated settlement agreement, the court will adopt this and this will be the final order? Okay. Do you recall signing this on November 20th of 2020?
Yes, ma'am.
Okay. That's all I have, Your Honor. I pass the witness.
Mr. Panzeca, anything?
No questions of Mr. Zascoda.
All right. Well, then, based on the testimony, grant the divorce, approve the property division and the terms for the custody and support of the child, and also approve the name change. So, anything else for today?
Do you need an entry date, Judge?
Yes, that'd be good. How much time do you think you'll need, Mr. Panzeca?
Well, I got about 95% of it done. Just, I guess, Friday, I guess.
I mean, is that gonna be enough time to get something to Ms. Vella and have her review that?
Well, make it the following Friday then, I guess, Judge. Will it have to be Zoom too? I guess so.
Well, not for an entry. If you just submit it, I'll just sign it.
No, I know, but if we have we would still have to go back to the mediator now that I'm thinking about it on a drafting dispute, if we have one. So you want to give us 30 days out just in case we have to go back? Hopefully that won't be the case. Forgot about that arbitration provision in the MSA.
Oh, we just have entry of March 2nd.
Okay.
And then if it's agreed to, you can obviously get it to me anytime before that.
Yes, sir. Will do. Marty, I'll send you an assignment of interest on that mobile home. If you can present it to Mr. Zascoda, I'd appreciate it.
I'll do that.
If you need anything for us to sign, let me know.
Thank you.
Thank you.
Well, thank you.
Thanks, Judge. Y'all had a good one. Thank you very much. Can we get off?
You can. The only other thing, I just wanted to compliment Miss Vella on her choice of artwork that she has hanging on the wall. She's right behind her. She obviously has very good taste.
What is that? Kyle Field? Is that Kyle Field? What is it?
So, Mr. Panzeca, you've never seen that?
What is it? I can't even make it.
Look at it, Mr. Panzeca.
What is it?
You see it?
Oh, Belleville Fab 4. Are you in there, Judge?
Yes.
Oh, I'll be damned. Look at there. Hey, that's pretty cool. I like that.
Well, We'll autograph one and send it to you.
I appreciate it, Judge. Thank you. Have a good week. Y'all be careful.